What is untouchability? What made it necessary for our constitution makers to include abolition of untouchability as a fundamental right? What laws are passed to enforce this right? And what is the penalty for violation of this right? Let's find out. Article 17 of our constitution abolishes untouchability in all its forms. Our pre-independence society was cursed with the cruel practice of untouchability. Under this practice, members of some sections of society were rejected or ostracized for belonging to a particular caste or tribe. This resulted in segregation of this section. The poorer section involved in so-called unclean occupations such as sweeping or leather work were historically segregated and banished outside the city limits. The practice included prohibition from entering places of public worship, prohibition from using common village paths, separate burial or cremation grounds, prohibition from accessing common public properties and resources, separate seating area for children in schools, bonded labor, etc. This compelled our constitution makers to make abolition of untouchability a fundamental right. Article 17 abolishes untouchability and its practice in all its forms. There are no exceptions here. The practice of untouchability has been made a punishable offence. The Untouchability Offences Act 1955 was passed to enforce Article 17. In 1976, the Act was amended and renamed as the Protection of Civil Rights Act 1955. This amendment enlarged the scope of the Act and made penal provisions more stringent. According to this Act, a civil right is any right accruing to a person by reason of the abolition of untouchability by Article 17 of the Constitution. Now the problem is that the term untouchability has not been defined either in the Constitution or in the Act. Whenever the interpretation of a term in the Constitution is not clear, we rely on the interpretation by the courts. The Mysuru High Court held that the subject matter of Article 17 is not untouchability in its literal or grammatical sense, but the practice as it had developed historically in the country. It refers to the social disabilities imposed on certain classes of persons by reason of their birth in certain castes. We have seen that untouchability is now a punishable offence. So what is the punishment for offenders? It is imprisonment up to 6 months or a fine up to 500 rupees or both. Secondly, a person convicted of the offence of untouchability is disqualified for the election to the parliament or state legislature. So what kind of acts are considered offences under this act? Preventing any person from entering any place of public worship, justifying untouchability on traditional, religious, philosophical or other grounds, denying access to any shop, hotel or places of public entertainment, insulting a person belonging to scheduled caste on the ground of untouchability, refusing to admit persons in hospitals, educational institutions, etc., preaching untouchability directly or indirectly, and refusing to sell goods or services to any person. The Supreme Court has held that the right under Article 17 is also available against private individuals, and it is the constitutional obligation or responsibility of the state to take necessary action to ensure that this right is not violated.